Ahearne. Thanks for your work, Tom, and thanks for being here tonight.
I take it this is on? Okay. I was asked to give a 15-minute update on the McClary v. State of Washington case, which the Supreme Court issued their decision in 2012. But actually, the update could be on the Seattle School District case, which was issued in 1978. Because in that case, you're indicating, am I not talking loud enough? Or come a little closer like that. Okay. So in the Seattle School District case, which was like over 40 years ago, the Supreme Court held the state system of school funding does not make ample provision for the education of the children residing within the district, that's the Seattle School District, and thus does not comply with Constitution Article 9, Section 1. Fast forward 40 years, McClary v. State of Washington case, the Supreme Court held the exact same thing. The state has not complied with its Article 9, Section 1 duty to make ample provision for the education of all children in Washington. The state has failed to meet its duty under Article 9, Section 1 by consistently providing school districts with a level of resources that falls short of the actual cost of the basic education program. Let's go back to Seattle School District case again. In that case, the trial court had said, legislature, I don't trust you. I don't think you're going to comply, so I'm going to retain jurisdiction. What did the Supreme Court do in the Seattle School District case? They said, well, we do not retain jurisdiction because we're confident the legislature will comply fully with its constitutionally mandated duty. Right. And it's comply fully, not comply-ish. It's comply fully. Well, now let's go forward to the McClary decision where the court said, what we've learned from experience is that this court cannot stand on the sidelines and just hope the state meets its constitutional mandate. A better way forward is for the judiciary, that's the Supreme Court, to retain jurisdiction over this case to monitor the state's compliance with its paramount duty. So in the McClary case, what happened? The ruling now was back in January of 2012. And what the Supreme Court has required as part of their retaining jurisdiction is every year the legislature has to report to the Supreme Court to say, look, we're on track to full compliance. So let's see, the 2012 legislature's compliance progress, the Supreme Court gave them an F. 2013, F. 14, F. 15, F. 16, F. All these years, the Supreme Court has reviewed what the state has done and said, you guys are not on track for full compliance. So what will the 2017 legislature, this is what's coming up now, this is going to be the showdown, what does the 2017 legislature need to do? What will Article 9, Section 1 compliance require? Because I keep saying Article 9, Section 1, Article 9, Section 1. What the heck is that? Well, that is Article 9, Section 1 of our Constitution that says it's the paramount duty of the state to make ample provision for the education of all children residing within its borders. Now, in this case, what the state's first argument was, well, let's look at that all children phrase. People all across the country have tried, and those kids in the lower socioeconomic strata, they never make it. So all children really can't mean all children. And the Supreme Court said no. All means all. Each and every child, no child is excluded, at least in our state. The next issue came up of, well, what does education mean? And the state has said that, well, it's a basic education. And we have basic education funding formulas. And as long as we're funding our funding formula, we're complying with the Constitution. We're funding basic education. And the Supreme Court said, no, education isn't defined by a funding formula. It's the basic knowledge and skills that are needed to compete in today's economy and meaningfully participate in our state's democracy. That's the purpose of an education. And the state said, well, that's a bunch of fluff. How the heck are you going to define what kind of skills, knowledge and skill kids need? And the Supreme Court said, legislature, you've already done it. When you passed House Bill 1209, which is now in the RCWs, you set forth the read with comprehension, know and apply core concepts of math, science, etc. You've said what all kids need to know. And you know what else you've done, legislature? You've established the essential academic learning requirements for our state. I mean, they're not optional academic learning suggestions. They're essential academic learning requirements which specify what all students, not most, all students should know and be able to do at each grade level. And we all know that the list of the 9 specific categories of essential academic learning requirements that the state itself has specified. So then we get to this ample provision part. And what does that mean? And the state had said that, well, ample, that just means adequate. And most school districts aren't going insolvent, so obviously the funding we're giving must be adequate. And the Supreme Court said, no, ample means considerably more than just adequate. To comply with the Constitution, you have to provide considerably more than just adequate. Which then brings us to the most important phrase, or one of the most important phrases, this paramount duty bit. And the state's argument had always been that, well, paramount duty, that just means like important consideration. And we spend billions of dollars on education. And so it's clearly an important consideration. We're complying. And the Supreme Court said, no, duty actually means duty. It's not a consideration. The state must amply provide for the education of all Washington children. And that word paramount, it actually means paramount, as the state's first and highest priority before any other state program or operation. So that's what the Constitution means. And the McClary mandate, the Supreme Court said in one sentence, to make it perfectly clear, Article 9, Section 1 confers on children in Washington a positive constitutional right to an amply funded education. I mean, remember, way back, Brown versus Board of Education, the Supreme Court said the Constitution confers on children a constitutional right to a desegregated education. Our Supreme Court said in McClary that our Constitution confers a constitutional right to an amply funded education. And this court even emphasized the civil rights foundation of education and ample funding when it said education plays a critical civil rights role in promoting equality in our democracy. And amply provided public education operates as the great equalizer in our democracy, equipping citizens born into underprivileged segments of our society with the tools they need to compete on a level playing field with citizens born into wealth or privilege. And summarized very succinctly, education is the #1 civil right of the 21st century. And the Supreme Court made it very clear that what remains to be done to achieve compliance is undeniably huge. And why does it say that? Look at what the state itself told the Supreme Court. The state told the Supreme Court that, look, in the 08-09 school year, we're funding about $6,800 per kid. But Supreme Court, trust us, by 2018-19, we will be funding over $16,000 per kid. Trust us, that's what we're going to do. So what does steady progress look like through that? Well, steady progress would look something like this on the per pupil funding by the state. And this is state funding above local levies, above federal funding. This is the state funding above that. What was our actual progress so far? It's less. And so that is why the Supreme Court said that what remains to be done in this last year that's remaining here, that blank year, is undeniably huge. So let's go to McClary v. State of Washington. And what the court has said is if the state's funding formulas provide only a portion of what it actually costs the school to pay its teachers, get its kids to school, keep the lights on, then the legislature cannot maintain that it's fully funding basic education through its funding formulas. So what is on track for the 2017 legislature to comply? Well, they have to address, do the state's funding formulas fully, not partially, fully fund your school district's actual cost to implement the components of the state's basic ed program? That's transportation, the MSOCs, material supplies and operating costs, all-day kindergarten, K-3 class size reduction, the other components like the highly capable programs, special education programs, Core 24, and compensation to attract and retain competent personnel. Those are the components that the legislature itself has said is their basic education program, and the legislature in 2017 is going to have to establish funding for those. Transportation, right now we know that the transportation funding formula, it funds the lower of last year's actual costs or statewide average, whichever is lower. That's not your actual costs this year. Material, supplies, and operating costs. Those MSOCs, those are based on statewide averages and an old snapshot from the 07-08 school year. That's not actual costs today. all-day kindergarten and K-3 class size reduction. The funding formulas partially fund your actual compensation costs, and they give partial assistance for some of the capital costs. You can't have smaller classrooms if you don't have more classrooms. You can't have all-day kindergarten instead of just half-day kindergarten without more classrooms. The state Supreme Court's rulings have said the state has to be amply funding those as well, but right now they're not. All these other programs that are part of basic education, highly capable, special education, the ELL programs, those are less than the actual student caseload, and they're funded at part of the actual personnel costs. They're not on track right now. And then compensation to attract and retain competent personnel, well, again, as you all know, it's partial funding. And there are significant teacher shortages even when you add local levy money and federal money on top of that. So that's not even close to fully funding the actual cost. Which then raises the last question of, can the Supreme Court actually force the legislature to comply? And the Supreme Court of Washington has said, well, look, we've got all these options of what we can do to force you to comply. And I'm just going to focus on two of those. Option number 6 by the Supreme Court is prohibit any funding on an unconstitutional education system. Well, what the heck does that mean? Well, for example, does the court want to strike down every underfunded school statute? That's the option that some people refer to as, they're going to close the schools. Well, the purpose of a sanction is to force the legislature to actually obey the Constitution, obey the oath they took to uphold the Constitution. Other state Supreme Courts have done exactly that. And I'll pick out 3 examples: Arizona, Kansas, and New Jersey. In each of those cases, each of those states, the state Supreme Court said, legislature, our Constitution requires you to be funding this particular program or this aspect of the public schools. In those 3 states, the legislature said what a lot of legislators here are saying is, court, remember your basic civics with separation of powers. You can't appropriate money out of the state treasury, so you can't do anything, nanny, nanny, boo-boo. In each of those 3 states, the Supreme Court said, well, you're right. We can't appropriate money out of the state treasury, but we can invalidate unconstitutional laws, and we've been telling you, legislature, the way you fund your school statutes is unconstitutional, and so first day of school next year, we're going to invalidate the school statutes in our state unless you comply with our order. Arizona and Kansas, they called themselves into special session, and they actually appropriated the money to comply. New Jersey, the legislature said, Supreme Court, you're bluffing. You're never going to do that. And in New Jersey, first day of school rolled around, and in New Jersey, the school year is the same as the fiscal year, so technically the first day of school is July 1. July 1 came around, Supreme Court said, fine, all the school statutes are invalidated, so that, the summer school kids got some time off. The legislature reconvened, and they had to impose some taxes and raise revenue so they could actually comply with the court's school funding ruling. So that's what's happened in some other states. Another option is this order any other appropriate relief. Well, what the heck does that mean? I mean, I think of that as like when I was a kid and me and my 4 brothers and sisters would be goofing around in the back seat of the car, and Mom would take the rearview mirror as she's driving and go, "Don't make me come back there." And we'd all quiet down because we didn't want her to come back there, even though if we thought about it for a second, she really couldn't do that while she was driving. But other appropriate relief, what could that possibly be? Well, one of the Supreme Court justices actually suggested one of the things during the contempt hearing back in 2014. And that we could invalidate all the tax exemption statutes passed by the legislature. Because if the legislature is saying they're pleading poverty, we don't have the money, well, there are about $15 billion of tax exemptions on the books. They can invalidate those. And what's important to remember here is invalidate the tax exemption statutes passed by the legislature, not those by voter initiative. Because the sales tax exemption on food, that's a voter initiative. That's not the legislature. So you can invalidate all the tax exemptions by the legislature, and you're going to leave the sales tax exemption on food in place. And that's a big target because Washington State gives a lot of tax breaks. Number 1 in the country for giving out tax breaks is the state of New York. Number 2, and usually it's good to be ranked high, but is the state of Washington. We're number 2 in the entire country. So that's a big target. So that leaves us with the answer, can this court force compliance? Yes. Last thing I'm going to talk about then is what are the next steps under the Supreme Court's order of what's going to be happening next. First, the 2000 regular session is coming up, and the Supreme Court's order has said the state must enact appropriations to achieve full constitutional compliance by September 1 of 2018. 2, 30 days after the governor signs the budget, the state has to file their report and legal briefing with the Supreme Court to say that they've done it. 30 days after that, we file our brief, our response, and I would be shocked if our response is going to be anything other than they haven't done it, because I would be shocked if they have done it. Step number 4 is after reviewing everything, the Supreme Court says we'll decide what to do. And that's sort of vague, but what could that be? It could be they could issue another order. They could have another hearing, like we've had hearings before. They could ask for more briefing, fine. They could appoint a special master, and what a special master would be is basically the Supreme Court saying, we don't do trials. They'll send it down to a Superior Court judge and say, hey, you do a trial and figure out what the facts are, tell us what the truth is, and we'll just go on whatever it is you say. Or they could give up. And there's a lot of pressure on the Supremes to just give up. And, I had that little map with, Arizona, Kansas, and New Jersey where the Supreme Court stood firm and made the legislature back down. Well, Ohio went through the same exercise, and in Ohio, the Supreme Court backed down and gave up. So the question is going to be, is our Supreme Court going to give up or not? And that's all I have, and I hope I stuck to my 15 minutes, and I'm happy to answer any questions if people have them, but otherwise I'll roll away. Thank you very much.
Don't go too far. I think we have some questions.
I appreciate your presentation. My understanding of the New Jersey situation, they have very similar constitutional language to Washington State's language, but it took 10 years from the time that they had a ruling to when new dollars actually flowed to the classroom. Is that correct?
Okay, a couple things. One, the language is not similar. Actually, one thing we have in Washington is we have the strongest language in the country. In fact, ours says it's the paramount duty of the state, blah, 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 blah. There's only one other constitution in the country that says paramount duty. That's Florida, and it says a paramount duty, so that's one of many. So ours is stronger. With respect to the timing, yes, it took an awful lot of time for the money to actually start coming in because there were years of this going back and forth between the Supreme Court saying, do it, and the legislature saying, well, we'll do part of it, but we ain't going to do all of it. Going back and forth, and so that's why it took a lot longer. And just if I can say one other thing, we filed this lawsuit in 2007. Right. So that was 10 years ago. And the other irony here is, the case is called McClary because the lead plaintiffs are the McClary family. Stephanie McClary, the mom, was 13 years old when that Seattle School District ruling was issued. When we filed the lawsuit, her daughter, Kelsey, was 13 years old. An entire generation has passed already.
So to follow up, and I appreciate the clarification on that, but what can we learn from the New Jersey case? Because I frequently hear that our language is stronger, but their language should compel their legislature to move forward. What can we learn from that experience so that we don't have to go through another 10 years of waiting for the legislature to actually comply with the Constitution?
Well, there are two things. One, the Supreme Court has to be firm. And our Supreme Court, I think, has been very clear in what the requirements are, but they haven't laid down a very firm sanction like, first day of school next year, if you're not complying, we're shutting the schools down. Or we're going to invalidate all the tax exemptions. And you want to get Microsoft and Amazon and Boeing's attention, that would do it. So one, the Supreme Court has to lay down a serious threat that the legislators believe, because no one believed these threats in Arizona, Kansas, and New Jersey. Finally, Arizona and Kansas, the legislators believed it. In New Jersey, it took the Supremes actually closing things down. So that's one. Another is legislators have to understand what the McClary case is. They have to understand what the Constitution requires, and they have to understand that even though they spend billions and billions of dollars, and even though they've added billions of dollars, which isn't really new money, it's just maintenance level funding, they have to understand what the needs are in today's schools. And that is something I know that you already know, or actually everybody in this room who just listened to what I said, they know more than virtually every single legislator about what the McClary case stands for and what the Constitution requires. Because my experience, with all due respect, is they're pretty clueless, and I think to get things to move forward, they have to be educated on what that oath they took to obey the Constitution actually means and what the Constitution means.
Director Harris.
Thank you for coming, Mr. Ahearne. As you know, you're one of my heroes. Today, it's $45.8 million in $100,000 a day fines.
Okay, I'm sorry. Go ahead.
But I guess part of my question is, how many millions of dollars were spent by independent, in quote, entities to try and knock off 3 of the Supreme Court justices in the last election?
I have not reviewed the PDC filings, so I don't know what the numbers are for that. But the bad side, or the disappointing side I saw was when they were trying to knock off the 3 justices. And I've been spending some time out in Spokane recently, and before the election, seeing the ads that the Republican Party was running against the 3 justices, because citizens, if you vote for them, they are going to impose an income tax on you, which of course is not what a court can do. So I was disappointed with that. I was encouraged by the election results. I mean, there was an awful lot of money put into defeating those 3 justices, and they all won handily.
Thank you.
All right. Thank